Thank you, Assemblyman, for your presentation. And we will now go to, oh, I'm sorry, that bill is on call. My apologies. Assemblyman Gibson, would you like to present, or we have another member here? If you're trying to pull together some chits, you know, I mean.
Not that generous.
No, all right, we'll proceed then with file item 7, AB 709. Good afternoon, Assemblyman.
Thank you very much, Madam Chair and Senators. Thank you for giving me this opportunity to present Assembly Bill 709, which seeks to require charter schools to comply with the same transparency and accountability law as traditional schools. This bill will require that the charter schools explicitly comply with the Brown Act, the Political Reform Act, the Public Records Act, and the Government Code 1090. Current law gives broad authority to the charter schools and exempt them from having to comply with the majority of the law that other school districts have to comply with. However, the requirement of this bill currently applies to a variety of public and private entities and are beyond the scope of the intended charter school exemption. In addition, due to the nature of the charter schools, it can be argued that the provisions of this bill are actually a clarification of the current law. Given the fact that these charter schools are publicly funded, the least we can do is to ensure that our children are educated by an institution that operates under the law to ensure sound governance. Here with me to provide supporting testimony is Seth Gamble from the California Teachers Association and Jeff Frost from the California School Board. And I request an aye vote.
Thank you very much. First witness.
Madam Chair and Senators, Seth Bramble here on behalf of more than 300,000 members of the California Teachers Association, proud to co-sponsor. In fact, now we represent more than 5,000 educators who are working at California's charter schools, which, as the Assembly member mentioned, are public schools that were established with a promise. We will give you the freedom to innovate, and you will show us results. Charter schools were established as lighthouses, a place where you could do something a little bit different, and perhaps we would learn something that would benefit the entire system of public education. I did attend a meeting of the Little Hoover Commission in Oakland a couple years back and was excited to hear from the director there of Oakland Unified's Charter School Division about a system he called knowledge transfer, where the principals at charter schools and the principals at traditional public schools would come together and talk about best practices. That's what was intended here, lessons learned. But the people cannot learn from this innovation if the people's business is conducted in private. The establishment of charter schools was not us, the public, yielding control to the agencies that serve us. To the contrary, we insist on retaining control and on staying informed. Having private and secret meetings to talk about how tax dollars are being spent is not innovation. It does not benefit the system, and in fact, it's resulted in a number of horror stories, some of which were outlined in the committee analysis today. What this bill is saying to charter schools is do what you want, but do it out in the open where everyone can see. What this bill is saying to charter schools is, dream big and think outside the box, but don't abuse the public trust and spend those tax dollars on our kids. Spend it on our students. We urge your aye vote.
Madam Chair, Jeff Frost, representing the California School Boards Association. We were co-sponsors of this bill a year ago with CTA, and I think sponsored it the year before that. Our view is that public schools or charter schools are public schools. They should follow the same rules, regulations, requirements, open meeting laws, etc. In our discussions with the charter organizations, clearly the big issue is whether they should fall under the Government Code 1090 issue. I think there can be compromise in other areas, but that has been the sticking point. The charter proponents will say that if there is malfeasance, you can do it under different regulations. But again, our view is that because they are public schools, they should be subject to the same requirements that a school board member is in terms of public disclosure, not self-dealing, et cetera. So for those reasons, we support the bill. Thank you.
Thank you very much. Any other witnesses in support? If you just step to the mic, we have one on each side, so we can move this along if we need to. Name, rank, and serial number, please.
Thank you, Madam Chair. Tristan Brown with the California School Employees Association, a co-sponsor of this bill, here in strong support. Thank you.
Thank you.
Madam Chair, Nick Romley on behalf of the Association of California School Administrators and also on the San Francisco Unified School District, both in support.
Thank you.
Madam Chair, Ron Rapp on behalf of the California Federation of Teachers, speaking in strong support.
Thank you very much.
Thank you, Madam Chair. Members, Mitch Seaman with the California Labor Federation, also in support.
Thank you. Witnesses in opposition? Good afternoon.
Good afternoon, Madam Chair, members. Rand Martin here on behalf of the California Charter Schools Association advocates. First, I would like to point out, contrary to your analysis, that we do support a statute. There are 4 laws that would apply to charter schools under this bill. We actually support 3 of those: Brown Act, Public Records Act, and the Political Reform Act. We would like to see those become law. The sticking point for us is Government Code 1090, and I do have a witness here who will elaborate on that. But it's important to point out that Government Code 1090, the problem for us is that it's absolute. It does not allow charter school board members who step up far more frequently than they would often like, I'm sure, to keep charter schools open. 1090 applies to you, it applies to members of the city council, school board trustees, and and not to take any away from any of you sitting up there, but I'm not sure that any of you would take a loan second out on your house to help the state of California close any budget deficit. But California, I'm sorry, Mr. Wykowski would, obviously.
I was going to say maybe we could that we have with the loan on our house.
That's another topic for another.
I'm not sure that your house, well, I don't know how valuable your house is.
Let's get to our business here. We're moving slowly today.
I appreciate that. Charter school board members do step up, take out seconds, provide low interest, no interest loans to charter schools to keep their doors open. If they are prohibited under Government Code 1090 from doing that, then it means that that very important access to finances to keep schools open is taken away from us. I also want to point out that the proponents and even the analysis highlights several horror stories that talk about why this bill is necessary. I ask you, not now obviously, to dig deeper into those horror stories. 2 of them that are highlighted in the analysis having to do with FCMAT audits, and for those who don't know, FCMAT is a team that comes in from the Department of Education to help a school district and a charter school deal with financial problems. Those are FCMAT audits. They were not abuses, they were not fiscal mismanagement, they were not fraud. And those are the kinds of stories that are being put out there as indications of why this bill is necessary. We want to make clear that while there are horror stories, all of them so far have been dealt with under current law and would be dealt with even further under the 3 sections of the law that we think are important.
Thank you very much. Next witness, please.
Julie Umansky, VP Legal Advocacy at the California Charter Schools Association, in opposition to the bill. I'll keep my comments abbreviated, directed at Government Code 1090 in particular, and I think it's important to understand how inclusion of 1090 would negatively impact charter schools. You have to understand that although we are public schools, we do not have many of the powers that public school districts have. For example, we cannot levy property taxes on private citizens to build schools or to raise operating funds through parcel taxes. We can't render unilateral land use decisions in order to site a school. We can't take private property through eminent domain in order to build a school. We can't access tax revenue anticipation notes to balance cash flow. We depend upon the community of the school in order to get through issues, as Rand mentioned. We do have charter school founders and operators who have taken out loans on taken out seconds on their houses in order to finance the operations to get through the tough times when they are not able to get a facility from a school district as they're allowed to do under Proposition 39. We rely upon other charter school board members who have access to ready capital to get through cash flow tight situations who might have access to land or facilities so that our charter schools can open and operate. And this is what charter school founders and operators must rely upon. Application of 1090, by prohibiting someone from being on both sides of a transaction, would prohibit that person from participating on the board and participating in the governance of the school as is allowed under the Charter Schools Act to encourage the community to operate independent schools.
Thank you very much. Witnesses, other witnesses in opposition, please, your name, rank, and serial number.
Eric Premack with the Charter Schools Development Center. Our membership's a little bit different, has a lot smaller schools. Our concerns reach to the whole bill and not just 1090. Thank you.
Okay, thank you. Next witness in opposition, please.
Bill Lucia with Ed Voice. We please request that you don't make philanthropy a criminal felony. Thank you.
Thank you. Next.
Pilar Oñate Quintana here for the Barona Band of Mission Indians with an opposed unless amended position with a little bit of a twist, if I just might, for very quickly.
Please.
Barona, to our knowledge, has the only charter school actually on an Indian reservation. So we don't take issue with the with most of the bill. Our only request to the author has been that for purposes of Public Records Act access, that those records and that information be accessed through the chartering school district rather than on the reservation. So this is something that we continue to press and ask for in the context of this bill.
All righty. Very good. Thank you. Any other witnesses in opposition? Just a question. You know, if people want to be philanthropic, it's kind of hard to say you can't be. I'm just wondering, how do you respond to the concern that if people want to take out a second, want to make a contribution or what have you, that they're not going to be able to do that under the terms of this bill, which was the objection raised by the opponents? Can you respond to that?
Sure. You want to?
Sure. And so a lot of the horror stories that my colleague was referring to speak directly to examples where there has been, whether a lease or a loan of money, that has been very problematic. Folks, for example, leasing property and then charging twice the market value and pocketing the extra dollars. So it's been a problem. When the bill was in Assembly Education, one thing we heard from the opponents was this is putting folks in a quandary where they have to choose whether they want to give, you know, financially or sit on the governing board. And we would absolutely agree with that. You have to make a choice. You cannot sit on the governing board and have a financial interest in what's going on. You cannot funnel tax dollars into your pocket, and that's the intent of Government Code 1090, to protect the public. When you do have a financial interest, one quick example, it doesn't necessarily put you on equal footing with the rest of the members of the governing board. So let's say that you are the person who's giving a loan, and so now the charter school is dependent on you. You're not an equal vote now with the other members of the governing board. It's very problematic.
Senator Wieckowski has to leave. We'll have him ask his question, then we'll go back and continue that conversation.
My question was on the same thing. Is that if I understand it, you could negotiate that economic interest. It's just at the point after it's done, then you have to make that choice whether to continue. We would have to resign if you had a financial interest. Although I think if you had a financial interest going before, we have within 500 feet, we cannot participate in that decision making, even as, you know, as meager as it is. So all right, but if this is passed with that provision in, by operation of law, those folks would have to resign if they had a financial interest. Okay.
All right, if you'd like to respond very briefly.
Thank you, Madam Chair. Just a couple of things. One is, again, back to the horror stories. Yes, you can always highlight a handful of horror stories and say this is ubiquitous. It's not ubiquitous, and where there have been cases, as Mr. Bramble refers to, the law has currently taken care of them. The law, if it's adopted in 709, as we propose, would add certain things, like the Brown Act, where everything would have to happen in transparency in public with no secret meetings. Under the Political Reform Act, all of the members of the board would have to fill out the same Form 700 that you have to fill out, which discloses all of your financial interests. So there's a lot more transparency in those pieces of the bill. I would also point out, and for those of you who sit on nonprofit boards of directors, it's hard to get people on boards who are willing to commit and work. And if you've got somebody who's willing to commit and work and also provide financial relief to the organization, that's the kind of person you want to be on your board of directors. You don't want them to make that kind of a choice. It really is a Hobson's choice that disadvantages the charter school. We appreciate why they want to do this, but there are other ways of protecting the public's money, and we think the rest of the bill does a dynamite job of doing that. And if we can just take out 1090, we can also possibly get a signature. You know, this is the same bill that Governor Brown vetoed last year. We've been doing this for more than a decade. It's time to bring this debate to an end and do a bill that we can all support.
Thank you. Thank you. Any other questions? Seeing none, Assemblyman, I'd like you to close. Would you respond to the fact that this is very similar to a bill that got vetoed last year, the whole issue of 1090? If you'd incorporate that into your close, I think that would be
Sure.
insightful.
Thank you very much, Madam Chair. I would just simply say that when an individual who wants to remain on the charter on the board can either do so or act as a private donor. But we have examples now of individuals leasing to $1 of a particular place for a school, and we all know that $1 is good in the public's view, but also it's a huge tax write-off. That's another financial gain in which a entity or individual that's on the school board, on this governing board, can in fact receive. Two, this bill has been tried before. I believe that we're at a point now, and hopefully it passes out this committee with an aye recommendation, that we can have a conversation with the governor and come to a meeting of the minds where we can address this issue and he can sign this particular bill into law. We live in a day and age right now that our public, our constituency demands transparency as well as accountability. These charter schools have received public funds and are being treated differently from public schools. If a public school board member does something that vote on something that provides financial benefit, that person has just violated the law and should be held accountable. All we're saying is that the same rules should apply. We should level the playing field, and then we can move on with educating our children. This bill does that common sense approach, and I believe this was intended when the charter schools was actually enacted to have that kind of transparency. So I respectfully ask for your aye vote.
Thank you very much. Appreciate that response. Is there a motion? Is there a motion on file item 7, file item 7? Senator Hertzberg, would you like to make a motion? I can't. All right. We have a motion. And Madam Secretary, the motion is due pass to Senate Appropriations. Please call the members.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, no. Anderson? Hertzberg? Hertzberg, aye. Leno? Monning? Wykowski? 2-1.
2-1, that bill is on call. Thank you, Assemblyman.
Thank you very much.
Appreciate your participation here. We have file item 10, Assemblymember Chow. AB 964. Good afternoon.
Good afternoon, Madam Chair. The year 2014 was a record-setting year in terms of the number of security breaches reported. According to a January 2015 report by the California Attorney General's Office, there were 187 breaches reported to the California Department of Justice. And compared to 167 in 2013 and 131 in 2012. Under current law, if the personal information that was stolen was encrypted, the businesses and agencies are not required to provide notice. This provision serves to encourage businesses and agencies who store personal information to adopt encryption so that if information is stolen, that information will be deemed less vulnerable to abuse. However, the term encryption is not clearly defined in statute. Assembly Bill 964 defines, for purposes of the existing data breach notification requirements, and for businesses as well as for public agencies, the term encryption to mean render unusable, unreadable, or indecipherable to an unauthorized person through its security technology or methodology generally accepted in the field of information security. With that, I respectfully ask your aye vote.
Thank you very much. Witnesses in support? No witnesses in support? Is this one of the cheese stands alone? The cheese stands alone? Okay. Any witnesses in opposition? All right. Are there any questions? Senator Morlock.
Thank you, Madam Chair. I've tried to keep my questions to a minimum today, thanks to the long list of
We have a number of bills,
So
yes.
I'm just curious, Assemblyman, how your bill differs from AB 83 by Gatto, Assemblyman Gatto.
My bill only defines the term encryption, which is not clearly defined in statute. His bill does something else. I don't recall exactly the details of his bill.
Okay, thank you. Thank you, Madam Chair.
Okay.
Reasonable standard.
All right. Any other questions? Motion by Senator Hertzberg. I think that this is obviously important as we see more and more of these breaches that we've got to do better. This is not good. And I don't know about my colleagues, but I keep getting notices on a fairly regular basis that information is being compromised that one would expect to be protected. And I think it's going to be very important moving forward that we see more encrypted information. So I appreciate your taking that first step. And with that, would you like to close?
I respectfully ask for a vote. Thank you.
The motion is due pass to the Senate floor. Please call the members.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, no. Anderson? Hertzberg? Aye. Hertzberg, aye. Leno? Monning? Wykowski? 2-1.
2-1, that bill will be placed on call.
Thank you very much. Senator.
All right, we have Assemblymember Hernandez. We'll start with file item 6. And I believe you have 2 bills, that one and number 18. So let's start with 6. Good afternoon.
Good afternoon, Madam Chair and Senators. Item 6, is that AB 621 or is that 1506?
That's 621.
All right, thank you. I'll start with that one. All right. Thank you, Madam Chair and Senators. AB 621 will transform and modernize port trucking operations by providing a limited opportunity for amnesty for motor carriers that come forward and correctly classify their drivers as employees rather than independent contractors. There's been a serious problem with the misclassification of port truck drivers over the past few decades. The bill represents a common sense compromise in allowing the parties to come together, rectify the situation, and move forward in a productive manner. Under AB 621, port drayage companies will be provided an opportunity to voluntarily come forward to participate in a limited amnesty program by entering into a settlement agreement with the Labor Commissioner. Under the terms of the agreement, the motor carrier must agree to pay all wages and benefits owed to previously misclassified independent contractors, and all taxes owed to the state as a result of misclassification. In addition, the company must agree to classify any present or future commercial drivers as employees. In exchange, a motor carrier that enters into such a settlement agreement will be relieved of liability for statutory or civil penalties based on previous misclassification of drivers. AB 621 is an important first step in the effort to modernize and improve efficiency at our ports, which represent a vital component of our state and federal economy. AB 621 will incentivize motor carriers in port trucking industry to make the right decision for the benefit of all interested stakeholders. I have with me today Mr. Barry Broad on behalf of the Teamsters to speak in support of this bill.
Madam Chair and members, Barry Broad on behalf of the Teamsters. This bill is voluntary. I want to reiterate that again. No employer has to take advantage of it, but what has happened down at the ports is that several hundred cases have been filed with the Labor Commissioner, other class actions have been filed, and about 100% of them have gone against the employers, resulting in considerable liability for those companies. We think it would be good for the industry, for everyone, to sort of cut off that litigation as much as possible by encouraging people to come forward, to come in out of the cold, so to speak, if they want to, sit down with the Labor Commissioner, reach an agreement, settle cases in advance, and be able to get out from under the possibility of crippling penalties that would apply. We think that's good for everyone, will stop a lot of litigation from going forward, and will solve a problem that's been festering down there for quite a while. Urgent aye vote. Thank you.
Mitch Seaman with the California Labor Federation, also here in strong support of the bill. While this kind of misclassification does exist in virtually every industry, it really has become so commonplace when it comes to port truck drivers that we think this relatively dramatic step is necessary. But it does represent a compromise, and we think it'll do a lot to help make sure that the industry takes a step forward into the 21st century and begins treating their workers as employees as they deserve, and we urge your support.
Any witnesses in opposition? Would you like to close, and then maybe we'll have a couple questions? Assemblyman Hernandez.
I respectfully ask for an aye vote.
I have a motion, just a quick question, if I may. Sure. Amnesty means you still pay payroll and payroll taxes and everything else associated with that. What penalties would you be? Just maybe clarify. You said it, but I'm just curious because I'm.
Yeah, so it would be wages that that have gone unpaid. And
well, they received remuneration as an independent contractor. So okay, yeah. Go ahead. I apologize.
Well, there's a whole series of penalties on the wages. They have to pay $25,000 per violation. So per person, per violation.
Labor Commission?
Yeah, that's one of the penalties. There's another thing called waiting time penalties, which is a full month's wages in addition to the actual wages due. Then there are a whole series of tax penalties for failure to pay unemployment tax, failure to pay workers' compensation tax. I mean, the penalties can very easily far outstrip the actual liability for the wages and taxes.
So you have amnesty, but not from the IRS or the Franchise Tax Board or a workers' compensation carrier?
No, they would have to
settle with.
They would have to settle with them and get.
Well, the only amnesty they're getting is whatever penalties the labor commissioner would have.
And the Employment Development Department.
Yes. EDD, which would be payroll taxes, sort of a similar with the FTB. Okay. All right. Thank you.
All right.
Thank you, Madam Chair.
Any other questions? Is there any opposition to the bill? There is no opposition. A motion by Senator Hertzberg, if you'd like to close.
I respectfully ask for an aye vote.
Always a good way to end. All right. This is a due pass to a Senate appropriations. Madam Secretary, please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Aye. Morlock, aye. Anderson? Hertzberg? Aye. Hertzberg, aye. Leno? Monning? Wajkowski?
All right, that has 3 votes. We will place it on call. Thank you very much. And now the final bill that you have before us today is, I believe it's file item 18, which is AB 1506.
Yes, thank you, Madam Chair. I've got a good one here for Mr. Morlock, Senator Morlock. Thank you for allowing me to present this bill today. At the outset, let me say that as Chair of the Assembly Labor Committee, I strongly support the Private Attorney General Act, PAGA, and I believe it's a critically important enforcement tool. I also understand the importance of Labor Code Section 226 and believe the accurate pay stubs are the fundamental right to protect workers. However, it has also been brought to my attention that there has been some recent litigation against employers over what I would characterize as technical or minor violations of the pay stub requirement. Hey, thank you for that. Examples include litigation over very minor discrepancies in the employer name listed on pay stub. This is a bill to help bring some fairness and equity to business people that are doing their work correctly, are fair to their employees. I respectfully ask for your aye vote.
Thank you very much. Witnesses in support.
Good afternoon, Madam Chair and committee members. Jennifer Brewer on behalf of the California Chamber of Commerce, and we are in support of the bill and thank the author for bringing this measure forward. Our companies have seen an increase in litigation under PAGA for these type of violations under 226, which, while they are technical violations of the statute, they have not actually created any injury to the employee. This bill creates a fair balance from our perspective in that it gives the employer an opportunity to correct these technical violations, and if they don't, the employee can move forward with their lawsuit. If the employee has suffered injury, there is a separate section of 226 that allows them to pursue damages up to $4,000 for a statutory penalty. This bill does not impact that. So if an employee has suffered injury, they have a separate avenue. This is truly for those technical violations that an employer should be able to resolve before a multi-million-dollar lawsuit is potentially waged against them. So for those reasons, we are supportive.
Thank you very much.
Chris McKaylee, Madam Chair, on behalf of both the Civil Justice Association of California as well as the Ambulance Association. And just a story out of the Ambulance Association, there was a 10-year employee who obviously knew for whom they had been working the last decade and ended up suing under 226A6 as to the proper legal name, and the employer, the ambulance company, had to settle for $48,000 despite no showing of harm. We have seen an increase over the last 8 years of 400% of private attorney general actions, many of them under this labor code provision. And I would just note that in the bill, the employer is required to provide 3 years of corrected wage statements before this right to cure can benefit them. Thank you.
Thank you. Other witnesses in support?
Madam Chair and members, Mike Belote for the California Employment Law Council. These really do happen. Mr. McKaylee had an example. The one that I have heard many times is the law requires the inclusive dates of the pay period, and once or twice employers have said week ending on, but didn't say when the week began, and so no one was hurt. This would correct that. We'd ask for an aye vote.
Thank you. Other witnesses in support?
Very broad with the Teamsters, just to show we're open-minded.
Good to know. Good to know.
Madam Chair and members, Javier Gonzalez here on behalf of the California Restaurant Association in support.
Very good. Next witness.
Yolanda Benson, representing the California Asian Pacific Chamber of Commerce, also in support.
Thank you.
Melzer with Wine Institute, also in support.
All right.
Matthew Allen, Western Growers, also in support.
Such enthusiasm here. All right. Very good. Thank you.
Fred Main on behalf of the Chamber of Commerce Alliance of Ventura and Santa Barbara County in support.
Very good. Thank you very much. Any witnesses in opposition? Are there any witnesses in opposition? Any questions? Yes, Senator Leno.
We gave this bill a close review in the Senate Labor Committee, and we gave it a squeaky clean bill of good health. But I would suggest that the only thing the bill is missing is a co-author. If there is an opportunity, I'd be happy to co-author the bill with you.
I would love to have you on board.
Okay, thank you.
All righty.
Senator Leno, on that esteemed request.
I would love to have you on board as well.
Let's pile it on. Let's pile it on. All right. Very good. Thank you.
I'll take everybody who wants to be a part of it. This is a bipartisan bill.
That's a lot farther along than he usually is, so you're making progress. Are there any amendments under consideration? Are there any amendments under consideration? All right, well, apparently not, but if they do come, please note that you have a lot of support here. I thank you for bringing the bill. We have a motion by Senator Leno. Oh, it was Senator, I stand corrected. I'm easily confused, of course. All right, so with that, I think the Assemblyman is going to ask for an aye vote, and Madam Secretary, there is a motion due pass to a Senate appropriations. Please call the roll.
Jackson? Aye. Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Aye. Hertzberg, aye. Leno? Leno, aye. Monning? Wajkowski?
Good day so far.
All right, thank you. Our next.
Thank you.
4-0, we'll place that bill on call for the absent members.